CIA tells US court giving out Nigerian President Tinubu's records could damage national security, jeopardize its secret nature, expose classified information and sources. Now to the news info. United States law enforcement agencies have invoked the global response over requests seeking criminal investigative documents concerning President Bola Tinubu and others. This followed numerous Freedom of Information Act (FOIA) requests that plaintiff Aaron Greenspan submitted to the FBI, CIA, DEA, Executive Office for U.S. Attorneys, Department of State and the Department of Treasury, Internal Revenue Service (IRS). The case in the District Court of Columbia is numbered 123CV01816/BAH with Greenspan v. Executive Office for U.S. Attorney et al. The request sought criminal investigative documents concerning third parties Bola Ahmed Tinubu, Lee Andrew Edwards, Muiz Adegboyega Akonde, and Abiodun Agbele, who, according to plaintiff, participated in an international drug trafficking and money laundering ring with operations in Chicago, Illinois. The agencies insisted that giving out information on Nigerian President Bola Tinubu could cause damage to U.S. national security. How is them giving information cause national security to U.S.? I don't understand that. The position was stated in a memorandum filed by the Central Intelligence Agency, the Federal Bureau of Investigation, and the Drug Enforcement Administration before the United States District Court for the District of Columbia. Last year, the court declined an emergency application seeking to compel top U.S. law enforcement agencies to hasten the release of confidential information on President Bola Tinubu. In an update on the case, the three U.S. agencies had filed their defense against the summary judgment concerning President Bola Tinubu investigation records. The CIA provided an additional rationale for its global response, saying the CIA does not reveal the identity of its human sources because revealing the identity of a confidential source could expose agency tradecraft, other human sources, and specific intelligence, interests, and activities. Mary C. Williams, the Litigation Information Review Officer for the Information Review and Release Division at the CIA, further explained, human sources can be expected to furnish information to the CIA only when they are confident the CIA can and will do everything in its power to prevent the public disclosure of their cooperation. In the case of the person who has been cooperating with the CIA, official confirmation of that cooperation could cause the targets to take retaliatory actions against that person or against their family or friends. It also places in jeopardy every individual with whom the cooperating individual has had contact. Thus, the indiscretion of one source in a chain of intelligence sources can damage an entire spectrum of sources. As such, confirming or denying the existence of record on a particular foreign national like Tinubu reasonably could be expected to cause damage to U.S. national security by indicating whether or not the CIA maintained any human intelligence sources related to Tinubu and identifying any access or lack of access any such sources had to intelligence concerning him. According to the court documents, the remaining disputes involve defendants' global responses to plaintiff requests for records about Tinubu and the DEA's global response to plaintiff requests for records about Agbele. The plaintiff also sued the Executive Office for U.S. Attorney, Department of State, and the Department of Treasury, Internal Revenue Service, but on August 13, 2024, he voluntarily dismissed those defendants. The phrase global response originated from a FOIA case that sought information concerning a ship named the Hughes Global Explorer, and the CIA refused to confirm or deny its relationship with the global vessel because to do so would compromise the national security or divulge intelligence sources and method. According to the court documents, global responses are proper if the fact of the existence or non-existence of agency records falls within the FOIA exemption. The FBI and DEA properly asserted global responses under FOIA exemption 6 and 7C because the request seek criminal investigative documents pertaining to third parties that, if they existed, would interfere with the third party's substantial privacy interests in not being associated with law enforcement investigative records. The CIA properly asserted global responses under FOIA exemptions 1 and 3 because confirming or denying the existence or non-existence of records related to Tinubu would reveal classified information that is protected from disclosure by executive order and statute, to the extent that plaintiffs' attempts to argue that the existence of the requested records have been officially acknowledged, such that a global response could not be used. This argument will not succeed for numerous reasons, not the least of which plaintiff never demonstrated that such an acknowledgement had ever been publicly or officially made by defendants. The document reads there are 3 central questions before the court, and plaintiff's case fail at each step. First, whether an affidavit of an agent of the Department of Treasury (IRS) pierces the global responses of the defendants, who are not part of the Department of Treasury. That is, whether the affidavit of an IRS agent constitutes an official acknowledgement of the FBI, DEA, and CIA that the record requested by plaintiff exists under circuit precedent. The answer is no. Secondly, whether a complaint brought by United States Attorney Office of Northern District of Illinois seeking forfeiture of seized funds in Tinubu's bank accounts based on the IRS agent affidavit transformed the affidavit into an official and documented public disclosure, confirming that the FBI, DEA, and CIA records requested by plaintiff exist. The answer to that question is also no. If the agency were to invoke a global response only in instances where it possessed responsive records, that response could be interpreted as an admission that responsive records exist and could have the effect of confirming classified information. This practice would reveal the very information that the CIA must protect in the interest of national security. Ms. Williams explained that the CIA issued a global response stating that it could neither confirm nor deny the existence or non-existence of records concerning Tinubu during the relevant time period referenced in the request. An acknowledgement confirming or denying the existence or non-existence of such record would reveal classified intelligence information and jeopardize the clandestine nature of the agency's intelligence activities and/or disclose information about CIA sources and methods. Now, so are they trying to cover up for Tinubu? Adamu says, interesting to know that my president is running, if not own the CIA. It is enlightening, I'm telling you. So the CIA in USA are even trying to cover up for him. That is a drug baron. I don't understand. I really do not understand that this man has that level of influence, even up to US, trying to cover up his activities as a drug baron, as somebody that pushes drug. Abubakar Makinta says, if a whole USA and CIA will cover up for Tinubu, the level of corruption in Tinubu as a person is beyond redemption, I'm telling you. He has gone far ahead of us in this country, and he's not in our league at all. He's not. If USA can cover up for him, then waiting be Nigeria. I beg. It is well, my listeners. Over to you. Leave your thoughts in the comment section. Don't forget to like, to share, and subscribe. Thank you for listening. See you some other time. Bye.